What happens to your family, your home, and your money after you're gone? Estate planning isn't just for the wealthy. It's for anyone who wants to avoid chaos, court battles, and unnecessary taxes. Today, we are breaking it all down in a way that's simple, practical, and important for protecting your legacy. Here's what we will cover: what probate is and how to avoid it, how beneficiary designations work, why having a will matters and what happens if you don't have one, what power of attorney documents do, and finally, the different types of trusts and when they make sense. So let's start with the basics. What is probate? Probate can seem like a mystery. Most people know they want to avoid it, but they don't know exactly what it is. Probate is a court-supervised process that kicks in when someone dies without proper legal direction. It gathers up your assets, settles any debts, and distributes what's left based on either your will, or if there is no will, the default state laws. In Illinois, where we are located, probate is generally required when your combined assets without a beneficiary designation exceed $100,000. If it's less than that, a small estate affidavit might help you avoid the court process. So, what's one of the easiest ways to avoid probate? Beneficiaries. Any account with a beneficiary listed, like a 401k, IRA, or even life insurance, will bypass probate. The institution simply needs a death certificate, and the money goes straight to the person you named. In Illinois, you can even name a beneficiary for your home, using a transfer on death instrument, or TODI for short. That's a great way to keep real estate out of probate. What happens if I don't have a will? Without a will, your estate follows intestate succession laws, which means the court decides who gets what. And it may not be what you expect. For example, in Illinois, if you are married with children, only half of your assets go to your spouse, and the other half goes to your kids. Is that really what you intended? Also, without a will, the court appoints a guardian for any minor children. That might be someone you would have already chosen, but it also might not. A will lets you spell that out clearly. Let's talk more about beneficiaries. You can name primary and contingent beneficiaries on almost any financial account, and you are not limited to family. You can list a friend, a nonprofit, or even a trust. But here's the catch. You can't put rules on a beneficiary designation. If you want to control how or when money is distributed, that's where a trust comes in. This can be especially helpful in scenarios where the beneficiaries are minors and we want to control when they are able to access their inheritance. Other situations in which a trust may be desired include beneficiaries with special needs, beneficiaries who have difficulty managing money, or beneficiaries who are dealing with addiction. I will provide more details on using a trust later in this video. Another key part of estate planning is having power of attorney documents. There are two types. One for healthcare, so someone can make medical decisions on your behalf if you can't, and one for property, which gives someone the ability to handle financial matters for you. These documents only work while you're living. Once you pass away, the will, trust, and beneficiary designations take over. Also, you can name different people for each role, someone financially savvy for property, and someone with a calm head in emergencies for healthcare. So, let's talk about trusts, and why they're not just for the ultra-wealthy. The most common type is a revocable living trust. You can change it anytime, and it helps keep your estate private and out of probate. The majority of families we work with use this type of trust. The other type of trust is an irrevocable trust. These come in handy if you're looking to minimize estate taxes or protect assets in more complex situations. With an irrevocable trust, once the trust is created, it cannot be changed. The advantages of using these types of trusts are that they remove assets from your estate, potentially saving millions in taxes for families. They also may allow families to qualify for federal or state funding when it comes to Medicaid or special needs programs. So, why would someone use a trust instead of just a will? It avoids probate, it keeps your wishes private, it lets you add rules for how your beneficiaries receive the money, It provides flexibility if someone becomes incapacitated, and it can help with estate tax planning. At the end of the day, a trust gives you more control and peace of mind. To summarize, what we have covered today, let's look at 5 common estate planning mistakes. Number 1, forgetting to update beneficiaries after the birth of a child, divorce, remarriage, or any other life event. I can't tell you how many times we have seen this happen. We meet with people all the time who forget to add one of their kids to the accounts or still have their ex-spouse listed as the primary beneficiary on their investment accounts. Number 2, leaving everything to minor children without a trust. If you leave a large sum of money to an 18-year-old, what do you expect them to do? In many cases, they realize they can live off this money for the next 10 to 15 years while enjoying life. Once the money's gone, they're now in their mid-30s with no career or degree to support their lifestyle. Number 3, assuming a will avoids probate, which it doesn't. Proper beneficiary designations, and in some cases a trust, are your ticket to avoiding probate. Number 4, naming only one power of attorney with no backup. Life happens, and sometimes people aren't available to serve as your power of attorney when an emergency hits. So be prepared and name more than one individual. And number 5, not coordinating retirement accounts with the rest of the plan. So once your estate documents are complete, there's still work to be done. You have to re-register some of your financial accounts to the trust and add the trust as a beneficiary to other accounts. Estate planning can be complex, but it's one of the best gifts you can give your loved ones. If your family had to step in tomorrow, would they know what to do? That's the real gift of estate planning: clarity, protection, and peace of mind. Not sure where to start? We suggest 3 things. Number 1, review your current beneficiary designations. Number 2, talk to a qualified estate attorney in your state. And number 3, work with your financial planner to make sure everything ties together: your will, trust, retirement accounts, and healthcare wishes. Your estate plan isn't about documents. It's about your kids knowing what to do, your spouse not dealing with legal messes, and your values living on. That's what legacy planning is really about. If you found this video helpful, hit the like button and subscribe for more financial insights. Thanks for watching, and we'll see you next time. Once again, I'm Mike Heatwall, founder and CEO of the Dalla Group. If you are interested in seeing how we help our clients, visit us at www.thedallagroup.com. Give us a call or schedule a time to connect with one of our wealth advisors. We would love to hear from you.